One of the major disadvantages associated with delegated legislation is skeleton legislation. And regarding skeleton legislation, we would like to discuss a leading case, Field versus Clark of 1892, the judgment delivered by the Federal Supreme Court of United States of America, where it was expressed that the Congress has the gun and the gunpowder is both provided by the Congress in case of legislation to the administrative authority, and the administrative authority is to pull the trigger, but in case of delegated or subordinated legislation, the administrative authority has to manufacture the gunpowder also. So it would lead to arbitrariness and despotism. And the very second disadvantage is associated with delegated legislation is inadequate legislative control. So, regarding that, the control of delegated legislation by the legislature is not adequate due to the heavy workload. The legislature has no time to keep a full watch over what its delegates enact under the authority delegated by it. Sometimes the delegation is made in very wide terms, so it leads to arbitrariness. So now we go to the third one, and that is regarding inadequate judicial control of delegated legislation. The judicial control over the delegated legislation is not adequate. Often the delegation clause is made in unduly wide terms so as to make judicial control ineffective. Judicial control is dependent on the chance, and a person affected will risk expense and expend effort in challenging the other. And the fourth one, that is inadequate publicity. Inadequate publicity of the delegated legislation is another defect. In England, the Statutory Instrument Act 1946 has been passed for the publicity of the subordinate legislation or delegated legislation. There is a great need of such legislation in India. And the fifth one is legislation by reference, which creates another disadvantages in delegated legislation. The delegated legislation is also criticized on the ground that it leads to legislation by reference. In other words, a further criticism advanced is that the process of subordinate legislation or delegated legislation has to less satisfactory drafting than would be the case for a bill to be presented to the parliament. And the next one is it opposed to the doctrine of separation of power and opposed to the very principle of rule of law. The delegated legislation is also criticized on the ground that it is against the doctrine of separation of power and rule of law. It may result in concentration of power in a single person or body. the concentration of power in the executive or administrative authority is likely to make the executive or administrative authority arbitrary in nature. It will increase the arbitrariness of the executive and thereby the human liberty life will be hampered. And lastly, we could discuss about Lord Hewitt's book on new despotism. So, Lord Hewitt in England on the subordinate legislation or delegated legislation published a book New Despotism in which he clearly expressed the view that subordinate delegation or delegated legislation would lead to create the new despots, and those are the administrative authorities or the executive. So, this very book created an uproar in English Parliament. So, the English Parliament constituted a committee, and that committee is Donogmore Committee, which submitted its report in 1932 regarding that despotism, and in that expression of the report it suggested the very idea to curtail or to curb the very sub-delegated or delegated legislation made to the executive or administrative authority. So also in 1952, after the Second World War, another committee and a select committee of parliament was constituted as Davis Committee, and it submitted its report in 1953. It also suggested a curve or to curtail all the powers delegated to the executive or administrative authority to check and to control the very arbitrariness of the executive or administrative authorities.